So what is constructive knowledge or constructive notice? In Florida, particularly when you're dealing with a premises liability case, we need to prove that the property owner had notice of the dangerous condition. Actual notice is if they actually are aware of the dangerous condition and they failed to take steps to correct it or warn their guests. Constructive notice occurs where the dangerous condition had existed for such a sufficient period of time that they should have discovered it and they failed to do it. So an example of this might be at a grocery store. If you're at a grocery store and video surveillance shows that a liquid bleach bottle had leaked all over an aisle and someone came in and slipped and fell in it, one of the things that we need to prove as attorneys is that the store either knew about that leak or that they should have known about that leak and cleaned it up and warned and protected their guests. Now, in this case, let's say we have video surveillance that shows this liquid bleach had leaked on the floor and been on the floor for about 5 hours, and no one had come through and cleaned it up, and then a customer came through and slipped and hurt themselves. The fact that it had been on the ground for 5 hours in a grocery store where they know they have a lot of customers coming in and out of, and they need to always be vigilant about inspecting those floors and keeping them safe, that can be deemed constructive notice. If an employee is walking through an aisle and should have seen a dangerous issue on the floor but didn't and kept walking, that can be deemed constructive notice. If an employee walks through an aisle, sees a dangerous condition, and doesn't do anything to clean it up or protect guests, that's actual notice. They know about it. So that's sort of why the issue of notice is so important, particularly in a slip and fall or premises liability case. If you have questions about your case, give us a call at 1-800-TRIAL-PRO or chat with us through our website at trialpro.com.